there in the heading of C and rem, or most don't understand really what that means. That means an action against your property. Well, guess what? If somebody brings an action against your property, they need to have ownership or legal interest in your property. When you register your property with the county, you do not waive any rights in your property. You do not grant them any ownership or interest in your property when you register your property. Doesn't matter whether you register your property with the county. You're supposed to register your property with the county. That's only done to stop land disputes, so that somebody don't come along and push me off my land and say, this is my property. I got records filed. This is my property. That's what registration's for. But what they've done is these little public servants, through the Bar Association, direction from the Bar Association, have bastardized the system by taking every square inch of property and every person within their territory and taxing them. Okay? They don't have authority to do that. That's not what the registration process is for. So that's what the purpose of this hearing is. The powerful thing about this is when you spell it out and you lay it out in your paperwork, when I sue this guy in federal district court, this dumb attorney, and I name the judge as a defendant, he's going to have trouble trying to use his immunity to get out of it. Because there's no way he's going to have to be explained how, sir, you didn't understand you didn't have in-rem jurisdiction over Mr. Fadjol's property? Why would you proceed in this matter? He can't, he's going to have trouble getting away from the facts of the case. Now, these are just the basics. I'm moving on. Jurisdiction. You could, right there, I just taught you what jurisdiction is in three things. To get personal jurisdiction, you got to have service of process. It's the only way a court can get personal jurisdiction. Guy knocks on your door, Mr. Fadjol, you've been served. Like Brandon said, the complaint and the summons, it's got to be in there, okay? And tells you got, what, 20 days to respond, okay?
I think it's 21 days. In Louisiana, for the Fifth Circuit, it is 21 days.
So there's personal jurisdiction, okay? You got to have service of process. Them mailing you a letter, that's not service of process. That's an administrative law process. That's not judicial process. So they don't have personal jurisdiction. In order to have subject matter jurisdiction, here's where they'll throw a lot of people off. They'll say, Brandon, we can hear traffic court cases. We can hear tax cases. Yes, you can. Doesn't mean you can hear my case. Okay?
That's right.
Doesn't mean my case is a tax case or it's a traffic case. The only way they can get subject matter jurisdiction is somebody's got to have a civil complaint or a criminal complaint filed against you, okay? A civil complaint means a verified complaint by a real party saying how they were harmed or damaged by you, okay? That's what a civil complaint is. A criminal complaint must have a warrant of probable cause.
An affidavit of probable cause signed by a first-hand witness and a that testified to the witness of a crime. And here's a big thing, too, because they don't do that. They do not do that, and then it has to. So Louisiana, and I'll just stipulate this point too, it either has to be issued previous to the search and seizure of time or within 72 hours of the arrest or seizure of property. So
yeah, you can't get a warrant without an affidavit.
Right.
You got to have the affidavit first. Somebody's got to sign an affidavit saying, "Hey, this guy Brandon, he's doing all these bad things at his property, Judge. I need you to sign this warrant so I can go stop him." You got to have that. That's the affidavit of probable cause. And like Brandon said, how about probably 99 times out of 100, if you get certified copies of the file, and it's a criminal action, you probably won't have an affidavit of probable cause in there. So there's another way you attack them, okay? So that's your subject matter jurisdiction. The third way they try and move against you, which is so outside the Constitution, it's unbelievable, is an in rem action, okay? In rem action, guess what? That is an admiralty action. That's an action that they use at sea where they actually seize a ship, the cargo of a ship, okay? That's what in rem was basically. That's where that came from. It's an action against your property. But the only way that somebody can bring an action against your property is you must have ownership of the property or the legal interest in the property. If me and Brandon own the property, like whatever, 50-50, and we had a dispute with each other, and I sued Brandon involving the property, and I brought an in rem action, I could bring that action against Brandon because I have legal interest in the property. But if I have a dispute with Brandon and I don't have any ownership or interest in his property, there's no way on earth that I can bring an in rem action against Brandon's house or his property. Can't happen. Well, it's the same thing with your local municipality or your county, whoever. They can't bring an in rem action against property that they don't have ownership in and they don't have interest in. So there's the three basics right there. Here's how you can knock out probably 90% of your actions that are taking place in court to prove that this court doesn't have jurisdiction to hear this matter. And when you use that Pennsylvania citation I mentioned, which I could post in it's actually posted up on Telegram now, it flat out states that, here's the beautiful part about that citation and what Brandon was talking about, the full faith and credit clause. Because if Brandon lives in Louisiana, he could take that Pennsylvania citation and he could actually use it in his case. Because I can't be operating under a separate set of laws than Brandon. Hello, 14th Amendment. Equal protection under the law. I can't have more protections in Pennsylvania than Brandon has in Louisiana. Okay? So that ruling in Pennsylvania states generally subject matter jurisdiction and standing are separate matters. But if a statute creates a cause of action, which is every traffic citation, every code violation, every local tax you get, these are all created by statute. If a statute creates a cause of action and determines who may sue, there must be a party with standing. Standing means that you're directly affected by whatever I did, okay? I had to do something that directly affected you in some way. No one from your county's been directly affected by anything you did. The cop that gave you the traffic ticket, he's not directly affected by anything you did. They don't have standing in the matter, okay? This is the stuff you have to understand and get in your head and get the basics down. And once you get that, it's very easy to build off this stuff because now you know where you can trip them up. Because when they throw things at you, go, oh, wait a minute. You don't have this. You don't have that. Now, they're either going to let this thing go. It's either going to go off into the ether, which a lot of my things have gone on. Last 3 citations I had, one was mine and 2 of my buddy Carmen's. They went off into the ether, Brandon. They disappeared, okay? Everybody stopped contacting us. And nobody bothered us anymore. They didn't write us back and say, hey, we've dismissed everything. And they're never going to do that. You know why they're never going to do that? Because it's admission of liability. If they ever turn around and said, Mr. Fagiolo, we've dropped this case, guess what now I have? Not only do I have a common law abusive process that I can move against them, if they drop the matter that they previously tried to move against me and I got it knocked out legally by the judge dismissing it, now I can move in a malicious prosecution against them. Okay. Right. Now they just stepped into malicious prosecution. So rarely are they ever going to give you a document saying, hey, Mr. Fagiolo, you're right. We've dropped this matter. Because it'll be like handing me a malicious prosecution case. Here, Alphonse, go bang him over the head with this order that I gave you for malicious prosecution. So the way they generally deal with it is they will let the matter go off into the ether. They will just stop contacting you about it. You don't know what's happened with it. It just goes away. So.
Yeah, and I was just over here helping somebody in there. Hey, man, Meat, if you really want to help yourself here, you need to take the jurisdictionary course and understand that you had substantive rights that were violated on that. But to finish the idea of standing, this is the District of Columbia Court of Appeals, and you can see all this. Generally, to have Article 3 standing, a plaintiff must show that, 1, he suffered an injury, which means an invasion of a legally protected interest, which is concrete and particularized, okay, and actual or imminent, not conjectural or hypothetical. The injury was caused by person sued, and a court can likely redress the injury. That is standing. This is Article 3, Section 2, Clause 1. This is where it's coming from. Standing means the right to go sue, and you have to have a personal stake in it. You can't just willy-nilly. The township of Aston can't go, hey, by the way, we've got ownership or interest in your property over there. How you like that? Who said it? Well, the township did. That's a completely fictitious entity. Okay, this is a corporate body politic set up to regulate other corporate body politics. And it is not running at the same level of law as, say, this right here. Okay, that's just a fact. That's just a fact. Okay, and so with that, let's get back to the administrative law, because I want to finish this up, and then I'm going to share the complaint at the end, and we're going to go over some of these decisions that have come through and the importance of them. Okay, and why it is important for you. Nobody else can make these decisions for you or spark that fire within you to actually want to do this stuff. I can't do it. Everybody sends me stuff about how they want help. Well, the first thing I do is I load them up with 15, 20, 30 pages of stuff. When you get done with that, come ask me some questions. Okay. I'm at the point now where Gary and I have 3 cases ongoing. I've got the wildlife fisheries to do, and I've got those people that I'm already helping. I'm loaded down. There's no more I can possibly take on. But at the same time, if you do the research, I will continue answering questions, because genuinely, I do want to help you. If you don't put the effort in, if you don't put the $250 in, because what does the $250 for me and Alphonse really do, or anybody else? It takes away all that stuff you don't know, throws it out the window, and gives you a foundation to work from, to start asking decent questions, not hypothetical moot questions, right? Stuff that we deal with every day, like the David Straits and the David Wynn Millers, and the birth certificate and the social security number. These are losing avenues. We're not losers. We don't want to be losers. We want to keep going to these Article 3 courts and winning. Okay, that's what we're going to do. Okay, so with that, let's go back to administrative law, and let's read a little bit out of here. Sometimes the language of private rights is used in the administrative context. However, this language may simply signify a policy relevant to administrative law, encompassing both public and private rights. Because administrative agencies serve in part to effectuate the constitutional obligation of the executive branch to see that laws are faithfully executed, the public interest is an added dimension in every administrative proceeding. This public good doctrine, folks, it's got to be destroyed, because without individual liberty, there is no public good.
No, then you're living in a democracy. You're not living in a republic. Then that's 51 right. Beats 49 every time.
Yeah.
So 51% of the people say they own your property, they'll come take your property.
That's right. That's right. And this is where we're headed, but we've still got enough people to stop it. In addition, the public rights doctrine impacts administrative agencies. In certain areas, the principle applies that particular administrative agencies are created to protect the public interest. And here's the most important part: and not to vindicate private rights. Okay? You have to understand this. That's not what
they don't care about your rights. They're not dealing with your rights.
They're not. That court, this quasi-judicial court, cannot hear your rights. It doesn't have the jurisdiction to do so.
It's like McDonald's. It's like arguing the constitutional rights to McDonald's.
Right.
They're just dealing with their administrative law. Hey, listen, you got to wear a brown uniform and you got to come to work at 9 a.m. each day. That's their law, basically. They don't care about your constitutional rights. Well, who says I got to work? They don't care about that. It's administrative law.
Where private common law rights are at stake, the court's examination of the congressional attempt to control the manner in which those rights are adjudicated will be searching. However,
that's very searching. That means don't exist. Okay.
That means you can't enumerate them. Okay, so let's go back to this idea right here for the whole in-rem jurisdiction. Can a corporation own property? Yes, it can. Can a corporation invoke the liberties as secured by the Constitution of the United States? No, cannot. Only you can. The most powerful testimony that you can ever bring into court is what? First-hand testimony. It's the most powerful tool in your arsenal. Nobody else can speak for you. Nobody can plead the damages of you. Okay. However, Congress may create a private right so that it is closely integrated with a public regulatory scheme as to be a matter for agency resolution with limited involvement by the federal judiciary. These separation of power concerns are diminished where parties are not required to, but merely have the option of proceeding in an administrative form.
Have the option of proceeding. So when you show up to that quasi-judicial court and you don't show up and say, hey, listen, I'm here by special appearance to challenge the jurisdiction of this court. If you just show up, they take that as, they call it a general appearance, which means they agree that you're agreeing that court has jurisdiction to deal with this matter. If you show up and say, hey, I'm here by special appearance, and that's a real thing, I didn't make that up, that's actually taught in Kaplan's audio seminar that the attorneys take before they take the bar exam. It's called a special appearance, and it's basically invoked just to challenge the court's jurisdiction. It's basically saying, hey, listen, I'm only here today to talk about this jurisdiction thing. I don't care about the charges or any other crap. I'm here about the jurisdiction of this court. That's what you do at a special appearance.
Okay. So this is the section, I'm going to read this. I didn't highlight it, but this is the section where I found that each administrative agency, their limitations were set out in the act. The feds have an administrative act, and so does each state. Okay. All right. Administrative law originated in the development of constitutional perimeters to circumscribe the administrative process. Later, these constitutional limitations were codified by statute in such acts as the Federal Administrative Procedure Act and the State Administrative Procedure Act. I'm not bullcrapping y'all or telling y'all, and you can go look at this. This is the case notes and the case law that substantiate it. When you finally figure out how simple it is, you're not going to be in the world of clown cuckoo land. You're just going to start with the basics. Jurisdiction. How did you get it? Right? Where did it come from? It just, one guy told me the other day, the judge told him, I've got jurisdiction because I say so. Good. Okay. Right. Now I'll slam you with some judicial complaints and I'm going to bam you upside the head. No, just because you say so, that's not a substantiation of a claim. No. That's not how this system works. The administrative system substitutes administrative agencies for courts and making many determinations in the establishment and definition of individual rights. However, differences in the origin and function of administrative agencies and courts prevent the wholesale transplanting of the rules of procedure, trial, and review, which have evolved from the history and experience of the courts.
In other words, we don't need to follow civil rules of procedure and those rules of evidence, right? Isn't that what that says?
That's exactly what it says. Okay. So you've got us out here pulling up the state rules of civil procedure, the rules of evidence, and trying to go off these ideas. And yet this whole system is separated from that system. It's completely separated. They're not one and the same. And that's why Title 42 at 1983 is so easy to use against municipalities. Okay. Understand that, folks. It's set up just for municipalities, primarily for municipalities.
That's why they're considered persons in municipality. And listen, you can't sue the state directly, okay? But you could sue the employees of a state, okay? The employees of the state you could sue. But you can sue a municipality and their employees. In other words, the state government gave themselves immunity, not their employees. If their employees do something wrong, you can go after them. But the municipalities that are they're political, they're subdivisions of the state, basically. Okay, that's what your municipalities are. The state did not give them that protection, so you can go right after a municipality, just like you're suing your neighbor. Okay, and they can't hide from you. This is the beauty of that 14th Amendment that everyone hates. Okay, that's equal protection under the law. It's due process of law. And without that 14th Amendment, you'd never be able to get that state into court. I mean, that municipality into court and go after them. So be careful what you read on the internet from these people. You know, to me, 14th Amendment's probably that's probably my favorite amendment. Okay. I love that 14th Amendment because it just is all encompassing. Like me and Brandon were talking about. I can't be living under a separate set of rules than Brandon. Yeah, there might be certain differences with certain things, but in a serious case, I can't have certain rights that he doesn't have. Can't work like that. It's equal protection under the law. So if a case is decided one way in Pennsylvania, he could cite it right there in Louisiana and bang him over the head with it. Hey, here's what Pennsylvania said. Now, the best is to cite your state. You always want to cite your state first as far as case law, your state first, the Supreme Court second, and then out-of-state decisions after that. And I've seen a lot of lawyers, Brandon, use out-of-state case sightings. You know why they did that? Because in Pennsylvania, like I helped somebody with a phony dog attack. The dog never touched anybody, never bit anybody, but they called it an attack, okay?
Right.
So the attorney that filed the paperwork, she had no good case sightings in Pennsylvania to pull up from. So she cited New York case law she brought in, okay? So you're free to use, with the full faith and credit clause, you're free to use rulings in other states. Like I said, always you want to use your state first, Supreme Court second, and then other states' rulings. And the way Brand was talking about earlier, the pecking order, and get this in your heads: Constitution number 1, legislative law second, which is your state laws. Okay, administrative laws third. Remember, we were just talking. Me and Brand talked about administrative laws; they're third on the list, and court citings are fourth. Court citings are not laws. I can't invoke a court citing as a law. I can't bring a case based on a court citing. The way I use court citings, it's to support something that I plead. Case in point, Pennsylvania states, I had 4 great citings in Pennsylvania, that if there is no service of process, for whatever reason, if there's no service of process, the court has no personal jurisdiction, okay? So now I could plead, hey, Township of Aston never served me process. This court lacks jurisdiction. And then I pull up them 4 case citings and say, there it is. Here's the cases that used it, because no longer is that my opinion. If I didn't put those court citings under what I stated, they look at that and say, well, that's Mr. Fadjoel's opinion. No. When I pull those court citings in, because those court citings are saying just what I pled. Hey, the Township of Aston never served me process. This court never had jurisdiction in the matter. Now nobody can argue with this, because we have well-established case law from the Pennsylvania State Supreme Court. They're telling you right there, no service of process, no personal jurisdiction. That's how you use court citings, to support things, not to move things. That's my rant.
I'm good. Okay, so we'll start back up. Nevertheless, administrative proceedings may not be conducted as to violate fundamental rules of justice or permit informalities to prejudice the rights of parties. That's what they do every day. Administrative procedure is generally simpler, less formal, and less technical than judicial procedure.
We don't need those stinking rules. We don't need them stinking. We don't need those stinking badges. Remember, we don't need those stinking.
Yeah.
We don't need those stinking constitutions. We don't need those stinking rules. You know, that's what it is.
It's, in general, strict rules of evidence do not apply to administrative proceedings. In addition, the right to
forget about that. It's a copy, and it might have been falsified. You know, it's not an original. We'll accept that. But wait a minute, he made it on a Xerox machine, and look, you can see the copy marks. Oh, we don't care about that. They can do anything they want in these administrative law processes.
And they can. And here we go again, what we've told people, that you're going to get railroaded most of the times until, and maybe there's somebody like union member last week, that judge didn't want to test him, knew exactly what union had set him up for. And that was it. Hey, I'm not touching this with a 10-foot pole. But here we go. In addition, the right to jury trial in suits of common law preserved by the 7th Amendment is generally inapplicable in administrative proceedings. Okay. Hey, listen, that's a clear violation of your right to due process and face your accuser. Okay. Even above where it says the rules of evidence do not apply. That means they can just put anything willy-nilly in there. It can just be hearsay. It can be whatever. It doesn't follow the strict rules of evidence. Right.
No, and what Brad and I do is, when you get these administrative courts coming at you, our goal is to flip them into a judicial court. In other words, we're like Columbo. You know, you get this mailing in the mail, and you say, oh, wait a minute, I don't understand here. It says, without service of process, the court has no personal jurisdiction. Oh, wait a minute, I'm looking at this thing the attorney wrote. He's got no personal knowledge of anything. He signed it. Nobody else signed it. It's not a complaint. This court doesn't have subject matter jurisdiction. So we're like, you go in there like, all you're doing is you're banging them over the head with the actual law. And they can try and railroad you all they want, but you stand your ground and say, wait a minute, administrative judge or not, he's bound by that state and federal constitution, whether he's an administrative hearing judge or he's a real judge that's in an administrative process. He's bound by that constitution. If you're invoking your rights, he can't say, well, we're going to ignore them in this administrative law process. Now he's going to have trouble when I sue his rear end in federal district court. Now he took an oath to uphold the Constitution, and when I was in there invoking my constitutional rights, he turned his head to benefit who? The municipality, who pays his paycheck, who greases his palms. That's why he's turning his head. He don't want to let me win because that's more money for him and his buddies, the guys he goes to lunch with and plays golf with. So he don't want to let me win. So I'm probably going to get railroaded in any local municipal hearing thing I get. The best I can do down here is make something go away or make it go off into the ether, okay? I'm rarely ever going to get a judgment down in a state court. Probably, not unless I go to it, not unless I get out of the municipal court and go to like a state court.
The Superior Court. We've got
court,
they're called district courts here, right? The 19th JDC. That's a real court. It operates by the Louisiana Rules of Civil Procedure, and then I think it's the 6th or 7th that is the appellate court above it. But outside of that, you're really operating in administrative proceedings, and that's it. And so it's just like anything else. The IRS and everything else, those are administrative proceedings. You have to invoke your liberties, right? And when you invoke them properly, when the IRS starts sending you mail, all of a sudden at the end of the day, they don't want to mess with you anymore. They just go away. However, so let's finish this document up because I think people are starting to get the gist of what we're trying to explain here. Listen, guys, me and Alphonse aren't doing this because we learned this 2-3 years ago. This was an eye-opening couple weeks for us about a month ago. It was about a month ago, huh, Alphonse?
Administrative stuff. Well, yeah. I knew they were following process, and then when I read it, I went, "There it is."
There it is. There it is. You know it, but then you have to find what backs it up, right? And when you find what backs up your hypothesis, then you go, oh, "Okay, now I know where to hammer your asses," right? And so, administrative proceedings operate to the advantage not only of the litigants but also of the courts. So it's a proprietary relationship. But also of the courts, which are thereby relieved of some matters on their dockets. Okay. However, the United States Supreme Court has repeatedly emphasized in regard to fundamental rights that judicial action possesses a degree of security superior to administrative action. Do y'all hear that? It is above administrative action, okay? So when your rights are deprived in these little quasi-judicial courts and you actually know, and now take it, granted, wildlife fisheries don't want anything to do with me. I called 3 agents. I did my investigation. I gave them my address, told them come on over. And then of course, the Secretary of Wildlife Fisheries, after I talked to him and sent all my records requests, I'm sure it come down, don't go to that guy's house.
Don't they almost like, it's funny when you don't understand what they're doing to you. Like people have them up on this pedestal, like they're afraid of them. Then once you understand what's going on and you start talking to them, don't they become like little kids? Like you're dealing with like little kids that got caught stealing. He's got his hand in a cookie jar and you're going, I think you're stealing cookies. Oh, not me.
No, not
they're
me.
Like little kids, they don't know nothing anymore.
Yeah. Well, I asked the one agent I talked to, I said, hey man, have you ever read the Louisiana Constitution? And he goes, I don't think I have. And
That's funny. Because for him to get that position, he had to take an oath to the Constitution.
I said, well, let me read a certain article from this. I said, do you know Article 27? I sure don't. I said, it states unequivocally, all men and women have the right, the freedom to hunt, fish, and trap all aquatic life in the state of Louisiana.
Now, he worked for the wildlife
fisheries.
That one section, that is directly related to what he does, and he never read it.
Right. And so I went off on him a little bit. I did. I let a little anger out on him. I probably shouldn't have went as far as I did, but nonetheless, I did go about telling him how he's derelict in his duty, and he's totally ignorant of everything that he does. He needs to go check his life out. Like you need to go look in the mirror and see if you have a conscience, man. What you're doing is committing criminal acts against living men and women every day. That's your job. And you can't tell me that's your job description. But all right, so let's shift gears right here. I've actually
had them people say that to me when I said, "Hey, listen, you understand what you're doing is a crime." They said, "I'm just doing my job."
That's so
right. Your job is to violate my rights and commit crimes against me, and that's what their mindset is. Yes,
Okay, so let's do this little workshop right here, guys. I did make this for people. This is a little deal I made. So let's go through here just a little bit. We're just not much, but I want to impound in y'all's mind the rules of statutory construction, and don't ever let anybody else flim-flam you or pull you away from this. The Louisiana Administrative Procedure Act. Louisiana Administrative Procedure Act is a law governing procedures for state administrative agencies to propose and issue regulations. All right, so anytime you see the word regulation, that's the regulation of commercial activity. Period. I don't give a crap. Man cannot be regulated as a mere thing. Okay, just can't. And provides for judicial review of agency adjudications and other final decisions in Louisiana. It can be found in Title 49. And then we go through the definitions. Okay,
agency adjudications.
That's right. That's right.
These are These are, I would consider these parts of the executive branch. These agencies. Okay, they relieve parts of the executive branch. They have no judicial power.
That's right.
They can do internal things like you said, McDonald's with the brown uniform. They can't be judicial processes. Hence the administrative law that they're pulling you in.
That's right. So we'll go to party. Party means each person or agency named or admitted as a party or properly seeking and entitled as of a right to be admitted as a party. So let's go see person. Means any individual, partnership, corporation, association, governmental subdivision, and it just goes on and on. So the individual must be a sole proprietorship. It can be nothing else. It cannot mean, and we'll go down here to the rule. Okay, this is from the Supreme Court plain meaning rule. It's Latin, nociquitur associus. When interpreting a statute, courts avoid ascribing to one word a meaning so broad that it is inconsistent with its accompanying words. The starting point in construing a statute is the language of the statute itself. The Supreme Court often recites the plain meaning rule, that if the language of the statute is plain and unambiguous, it must be applied according to its term. And this is the inclusio unis est exclusio alteris, a rule of interpretation that states that including one excludes another. That's just the statement, no dogs allowed, under this rule would mean that panthers were allowed. That's just a fact. That's statutory construction. Okay. So then we just go to the Title 26, 77701. And I just did this for people to see how they match. Okay. The term person shall be construed to mean and include. So we've excluded something right here, guys. Okay. An individual, a trust, an estate, a partnership, an association, a company, or a corporation. So who owes taxes in the United States? Who owns income taxes, guys? Okay. This is a fact. This is a fact. You can't change how the rules of statutory construction go. And I don't know if I got anything else. Term United States when using the geographic.
And here's how simple that individual thing is. Imagine if they had, it's like putting man in a list with Mickey Mouse, Donald Duck, Daffy Duck. You can't have something that operates under one set of laws, basically the Constitution. Constitution doesn't grant you rights; it secures your rights. But we have access to that Constitution that administrative agencies do not. So you can't put us on a list with them and group us together. It doesn't work.
No, it doesn't. It doesn't. And I put two. I put one of your favorites, Newark Fire Insurance Company versus State Board of Tax Appeals in here. When a state exercises its sovereign power to create a private corporation, that corporation becomes a citizen and domiciled in the jurisdiction of its creator. There it must dwell. The dominion of the state over its creature is complete. So I went to another United States Supreme Court ruling too, and pulled Oklahoma Natural Gas versus the state of Oklahoma. And so the reason why I pulled these two, because they have the least amount of negative treatments, by the way. Newark is a great case to cite for anybody. It only has, I think, 2 negative citations, and they were used out of context. It follows, therefore, that as the death of the natural person abates all pending litigation to which such person is a party, dissolution of a corporation at common law abates all litigation in which the corporation is appearing either as plaintiff or defendant. To allow actions to continue would be to continue the existence of the corporation pro hoc vice. But corporations exist for specific purpose and only by legislative act, so that if the life of the corporation is to continue, even only for litigating purposes, it is necessary that there should be some statutory authority for the prolongation. The matter is really not procedural or controlled by the rules of the court in which the litigation pens. It concerns the fundamental law of the corporation enacted by the state, which brought the corporation into being. He who creates controls. All right. It is the simple ideas that we must come to understand. Okay. Learning how to navigate